The Senate Judiciary Committee hearing room carried an unusual tension that morning, as senators filed in for what had been announced as a routine oversight hearing on voting rights legislation, but everyone with any experience in congressional politics understood that nothing involving Ted Cruz and contentious social issues ever remained routine for long. The Texas senator had built his reputation on explosive confrontations during committee hearings, theatrical displays of righteous indignation that generated Fox News clips and energized his conservative base, while making him one of the most polarizing figures in American politics. Jasmine Crockett had been invited to testify as an expert witness, given her legal background in civil rights law and her direct experience with voting rights cases in Texas, and she sat at the witness table reviewing her prepared testimony, while cameras positioned themselves for optimal coverage of what everyone suspected would become a heated exchange. What nobody in that chamber anticipated, what Ted Cruz himself certainly failed to prepare for despite his legendary ego and his Harvard Law School credentials, was that the freshman representative from Texas was about to demonstrate that courtroom experience and careful evidence preparation created advantages that even the most aggressive senatorial grandstanding could not overcome. The confrontation that followed would produce one of the most dramatic moments in recent congressional history, a viral clip that would be analyzed by legal scholars and shared millions of times as the perfect example of how calm professionalism and factual precision could dismantle even the most bombastic political performance. Before we show you exactly how this explosive confrontation unfolded and why Ted Cruz's rant ended so abruptly that even his Republican colleagues appeared stunned by the silence that followed, make sure you hit that subscribe button and drop a like on this video so you never miss these extraordinary moments when preparation meets bluster and evidence trumps volume. Ted Cruz had spent more than a decade in the Senate cultivating an image as a constitutional conservative who fearlessly defended traditional American values against what he characterized as progressive overreach and judicial activism. His background included clerking for Chief Justice William Rehnquist, arguing cases before the Supreme Court as Texas Solicitor General, and teaching at the University of Texas School of Law, credentials that gave him legitimate claim to legal expertise that he wielded like a weapon in committee hearings and floor debates. He had developed a distinctive style during his Senate tenure that combined detailed legal arguments with theatrical delivery, often speaking at length about constitutional principles while managing to sound both professorial and passionate. His presidential campaigns in 2016 and beyond had reinforced his tendency toward dramatic rhetorical flourishes and his willingness to engage in confrontational exchanges that his supporters viewed as principled stands, while his critics characterized as attention-seeking, performances disconnected from genuine legislative work. His relationship with Donald Trump had evolved from bitter primary opposition to loyal alliance, requiring him to defend positions and behaviors that sometimes contradicted his earlier stated principles, a transformation that damaged his reputation among some constitutional conservatives while solidifying his standing with the MAGA base that now dominated Republican politics. The voting rights hearing had been scheduled after several states, including Texas, had passed legislation restricting ballot access in ways that civil rights organizations challenged as discriminatory and unconstitutional. Democrats on the committee viewed the hearing as an opportunity to build the public case for federal voting rights legislation that would override state restrictions, while Republicans saw it as a chance to defend state prerogatives and push back against what they characterized as Democratic efforts to federalize elections and enable voter fraud. The witness list included election administrators, legal scholars, voting rights advocates, and individuals who had experienced difficulties voting under new restrictions. Jasmine Crockett had been invited because of her dual status as both a sitting member of Congress and an attorney who had litigated voting rights cases in Texas courts, giving her direct knowledge of both the legal issues and the practical impacts of restrictive legislation. Ted Cruz had clearly prepared for this hearing with Crockett specifically in mind as a target for the kind of confrontation that would generate conservative media coverage and energize his supporters. His staff had compiled her previous statements on voting rights, her litigation record, and her congressional testimony, looking for inconsistencies or positions that could be characterized as extreme or disconnected from legitimate concerns about election integrity. He had undoubtedly anticipated that challenging a black female Democrat on voting rights would create exactly the kind of dramatic clash that played well with audiences who viewed voting restrictions as common-sense safeguards rather than discriminatory barriers. What his preparation apparently failed to account for was that Jasmine Crockett had spent years in courtrooms where aggressive questioning from judges and opposing counsel was routine, where emotional appeals were insufficient without supporting evidence, and where logical fallacies were immediately identified and exploited by skilled opponents. The hearing proceeded through its early stages with various witnesses presenting testimony about voter experiences, election administration challenges, and legal analyses of recent state legislation. Democratic senators asked questions designed to highlight stories of voters being turned away from polls or facing new obstacles to casting ballots, while Republican senators focused on the importance of election security and the legitimacy of state efforts to prevent fraud and ensure that only eligible voters participated. The partisan divide was clear and predictable, with each side emphasizing different aspects of the complex balance between ballot access and election integrity. When Jasmine Crockett was called to testify, she presented a measured analysis of Texas voting legislation, explaining specific provisions that courts had found problematic, citing relevant case law about constitutional protections for voting rights, and discussing her direct experience representing clients who had been denied the ability to vote under restrictive policies. Her testimony was detailed and legally sophisticated, referencing Supreme Court precedents including Shelby County v. Holder, which had struck down key provisions of the Voting Rights Act, and explaining how that decision had enabled states to implement restrictions that would have previously required federal pre-clearance. She discussed the legal standards courts use to evaluate whether voting restrictions violated constitutional guarantees of equal protection, explaining that laws with racially discriminatory impact could be unconstitutional, even without proof of discriminatory intent, if their effects were sufficiently severe and if states could not provide sufficient justification for the properly restrictions. She presented statistical evidence showing that certain provisions in Texas law disproportionately affected minority voters, elderly voters, and voters with disabilities, creating barriers that served no compelling state interest in preventing fraud or improving election administration. Her presentation was calm and professional, delivered in the style of an appellate attorney making oral arguments before a court rather than a politician trying to score rhetorical points against opponents. Ted Cruz had grown visibly agitated during her testimony, shuffling papers and conferring urgently with his staff in whispered exchanges that suggested he was preparing to launch an aggressive challenge to her presentation. When the committee chairman recognized him for questions, Cruz did not ease into his interrogation, but rather exploded immediately with the kind of volcanic rhetoric that had become his trademark in high-profile hearings. His voice rose sharply as he accused Crockett of presenting a fundamentally dishonest narrative about voting rights that ignored legitimate concerns about election integrity and portrayed common-sense safeguards as racist suppression. He gestured emphatically as he spoke, his face flushing with apparent anger, creating a visual spectacle of righteous indignation that his supporters would later share as evidence of his passionate defense of constitutional principles. His initial outburst lasted several minutes without pause, a technique he had perfected that allowed him to dominate the hearing room and prevent interruption while he built momentum for his attack. He claimed that Democrats like Crockett were deliberately conflating reasonable voter identification requirements with historical Jim Crow suppression, dishonoring the genuine civil rights struggles of previous generations by comparing modern election security measures to literacy tests and poll taxes. He accused her of cherry-picking statistics and ignoring evidence that voter ID laws had been upheld by courts and implemented successfully in numerous states without reducing turnout or discriminating against minority voters. He suggested that her real goal was not protecting voting rights but rather enabling the kind of loosened election procedures that Democrats believed would give them partisan advantage, and that her legal arguments were simply sophisticated cover for this nakedly political objective. The rant continued, with Cruz asserting that fraud was a serious concern that justified preventive measures, that maintaining public confidence in election integrity required verification procedures, and that states had constitutional authority to manage their own elections without federal interference, except in cases of clear discrimination that Crockett had failed to prove existed. He pointed dramatically at her, his voice reaching levels that echoed through the chamber, demanding to know why she opposed simple common-sense requirements that voters show identification before casting ballots, whether she believed that asking for ID was equivalent to Jim Crow oppression, and whether she could cite any evidence that eligible voters in Texas had actually been unable to vote under current law. The questions were delivered as accusations rather than genuine inquiries, structured to make any answer sound defensive or evasive, designed to create the impression that he was exposing fundamental flaws in her testimony through the sheer force of his aggressive questioning. Jasmine Crockett had remained completely calm throughout the entire explosion, her expression neutral and professional, not attempting to interrupt or respond until Cruz finally paused to catch his breath after his extended tirade. The silence that followed his pause was striking, as everyone in the chamber recognized that something significant was about to happen, that the contrast between his volcanic eruption and her composed demeanor signaled a confrontation that would not follow the usual script, where witnesses scrambled to defend themselves against senatorial assault. She leaned forward slightly toward her microphone, maintaining steady eye contact with Cruz, and began her response in a tone that was quiet enough to require attention but carried unmistakable authority that commanded the room's focus. She thanked Senator Cruz for his questions and noted that she would be happy to address each of his points systematically, using the evidence she had brought with her for precisely this purpose. The statement immediately reframed the exchange from emotional confrontation to factual analysis, suggesting that she had anticipated his attacks and prepared specific responses grounded in data rather than rhetoric. She began by addressing his claim that voter ID laws had been implemented without reducing turnout, pulling out a research study from her materials and citing specific findings that showed measurable reductions in turnout among minority, elderly, and low-income voters in states that implemented strict photo ID requirements. She noted that these findings had been published in peer-reviewed journals and replicated by multiple independent researchers, and that dismissing them required either ignoring the evidence or claiming that all of the researchers were engaged in coordinated deception, neither of which seemed particularly plausible. She continued methodically through each of his claims, presenting evidence that contradicted his assertions with the precision of an attorney making a closing argument to a jury. On his suggestion that fraud concerns justified restrictive measures, she presented data from Texas showing that the state had identified only a handful of actual voter fraud cases over multiple election cycles, far too few to justify restrictions that made voting significantly more difficult for thousands of eligible voters. She noted that courts had repeatedly found that preventing extremely rare fraud could not justify substantial burdens on legitimate voters, and that Texas had never provided evidence of fraud at levels that would threaten election integrity or justify the specific restrictions it had implemented. She quoted directly from judicial opinions in cases involving Texas voting laws, including language from federal judges appointed by Republican presidents, who had found that the state's restrictions appeared designed to make voting more difficult for constituencies that tended to support Democrats rather than to address any genuine security concerns. On Cruz's claim that she was dishonoring civil rights history by comparing modern restrictions to Jim Crow suppression, Crockett delivered what would become the most viral moment of the entire hearing. She noted that she found this accusation particularly interesting coming from Senator Cruz, and she paused briefly to let anticipation build about what would follow. She pointed out that the Voting Rights Act had been reauthorized with overwhelming bipartisan support as recently as 2006, signed into law by President George W. Bush, precisely because Congress recognized that discriminatory voting practices had not ended with the civil rights movement, and that ongoing federal oversight was necessary to prevent states from implementing new forms of discrimination. She noted that the Supreme Court's Shelby County decision striking down the preclearance formula had been decided by a 5-4 vote, with the dissent written by Justice Ruth Bader Ginsburg explicitly warning that eliminating preclearance was like throwing away your umbrella in a rainstorm because you were not getting wet. She continued by explaining that within hours of the Shelby County decision, Texas and other previously covered states had begun implementing voting restrictions that had been blocked under preclearance, suggesting that those states understood their proposed restrictions were discriminatory and had been waiting for federal oversight to end before implementing them. She presented a timeline showing the sequence of events, demonstrating that restrictive legislation followed immediately after the Shelby decision in multiple states. She noted that federal courts had subsequently found that several of these restrictions, including some in Texas, were enacted with discriminatory intent and violated the Constitution, directly contradicting Cruz's claim that modern restrictions bore no relationship to historical suppression. She suggested that perhaps Senator Cruz should read the actual judicial opinions in these cases, including opinions written by conservative judges, before accusing civil rights attorneys of dishonoring history by identifying ongoing discrimination that courts had legally established existed. The presentation was devastating in its combination of factual specificity and calm delivery. Ted Cruz's face had progressed from flushed anger to noticeably pale discomfort as Crockett systematically dismantled every claim he had made during his explosive rant. He attempted several times to interrupt her presentation, but the committee chairman, perhaps recognizing that interrupting her at this point would appear as an attempt to prevent damaging facts from entering the record, allowed her to continue responding fully to the questions Cruz himself had posed. Other senators on the committee, both Democratic and Republican, sat in unusual silence, clearly absorbed by watching a masterclass in evidence-based advocacy that was turning what should have been a hostile interrogation into a showcase for the witness's superior command of the relevant facts and law. Crockett had not finished delivering her evidence-based response to Cruz's rant. She addressed his demand for evidence of voters unable to vote under Texas law by presenting affidavits from her own clients, individuals who had been turned away from polling places despite being eligible voters because they lacked the specific forms of identification Texas required, or because their names did not exactly match between their ID and voter registration due to marriage, divorce, or clerical errors. She read portions of these affidavits into the record, describing elderly voters who had voted for decades but whose expired driver's licenses were no longer accepted, college students whose school-issued IDs were insufficient under Texas law while concealed carry permits were acceptable, and married women whose voter registration reflected maiden names while their IDs showed married names, creating discrepancies that poll workers interpreted as disqualifying. She noted that each of these individuals was an eligible voter whose ballot had been rejected, not because of any fraud or improper behavior, but because of bureaucratic requirements that served no purpose other than creating barriers to voting. She pointed out that Texas offered a process for voters without acceptable ID to cast provisional ballots if they signed affidavits explaining their inability to obtain ID, but that many voters were unaware of this option, that poll workers often failed to inform voters of it, and that the affidavit requirement itself created additional burdens that discouraged voting. She presented statistical analysis showing that provisional ballots cast under these procedures were rejected at higher rates than regular ballots, suggesting that the process was not an effective accommodation, but rather another obstacle that reduced participation. She then addressed Cruz's suggestion that she opposed all verification procedures by clarifying her actual position, which he had mischaracterized during his rant. She explained that she supported reasonable verification measures that balanced election security with ballot access, but that Texas law went far beyond reasonable verification by accepting some forms of ID while rejecting others in patterns that appeared designed to favor certain constituencies. She noted that Texas accepted concealed carry permits, which were disproportionately held by Republican voters, while rejecting student IDs issued by state universities, which were disproportionately held by Democratic voters, despite both documents providing comparable identity verification. She suggested that if election security was the genuine concern, there was no logical reason for this distinction. But if the goal was to make voting easier for Republican constituencies while creating barriers for Democratic constituencies, the pattern made perfect sense. The implications of this observation were explosive because it suggested that the very restrictions Cruz was defending as common-sense security measures were actually partisan voter suppression tactics, and Crockett had presented evidence that made this characterization difficult to dismiss as mere partisan accusation. She noted that federal courts had found that Texas had enacted its voter ID law with discriminatory intent, a judicial finding of fact that Cruz appeared to be either unaware of or deliberately ignoring in his defense of the law. She offered to provide him with copies of the judicial opinions if he was unfamiliar with them, a gesture that appeared courteous but carried the unmistakable implication that his ignorance of relevant case law was embarrassing for someone who claimed legal expertise. Ted Cruz had fallen completely silent during the latter portion of Crockett's response. His earlier explosive energy entirely dissipated, as he apparently recognized that continuing to engage would only provide her with additional opportunities to present evidence that contradicted his claims. His expression showed a mixture of anger and discomfort, and several observers noted that he appeared to be receiving urgent messages from staff who likely recognized that this exchange was not creating the viral moment they had hoped for, but rather one that would be politically damaging. When Crockett finally concluded her response by thanking Cruz for the opportunity to present the evidence supporting her testimony, and noting that she remained available to answer any additional questions he might have, he simply shook his head and indicated that he had no further questions. A stunning retreat from someone known for never voluntarily ceding the floor during contentious hearings. The silence that followed was remarkable and extended several seconds longer than normal pauses in congressional proceedings, as everyone in the chamber processed what had just occurred. A senator known for bombastic, confrontational style had launched an explosive attack on a witness, expecting to dominate the exchange and create favorable media clips, only to watch that witness calmly present evidence that not only refuted every point he had made, but also exposed his arguments as factually inaccurate and legally unsound. The contrast between his volcanic rant and her composed, evidence-based response could not have been more stark, and the fact that his rant had ended so abruptly with him declining to ask follow-up questions, despite having dominated the floor for extended periods in previous hearings, made clear to everyone watching that he recognized he had been thoroughly outmaneuvered. Democratic senators on the committee seized the opportunity to follow up on points Crockett had raised, using their question time to allow her to elaborate on the evidence she had presented and to enter additional materials into the hearing record. Republican senators, meanwhile, largely avoided engaging with her directly, apparently having learned from Cruz's experience that aggressive questioning of this particular witness risked similar embarrassment. The remainder of the hearing proceeded with notably less theatrical confrontation than its opening suggested would occur, with senators focusing more on other witnesses and less contentious aspects of voting policy. But everyone present understood that the defining moment had already occurred and that the clips circulating on social media would focus exclusively on the Cruz-Crockett exchange. The video of the confrontation began spreading across social media platforms even before the hearing concluded, with multiple clips from different angles being shared and reshared as viewers marveled at the dramatic contrast between Cruz's explosive opening and his silent retreat after Crockett's evidence-based response. The hashtag #CruzDestroyed and Crockett Evidence began trending nationally within the first hour, joined by receipts not rants as commentary on how thoroughly she had supported every point with documentation and data. The clips accumulated millions of views as they spread across Twitter, Facebook, Instagram, and TikTok, with political observers and legal experts providing analysis that consistently praised Crockett's preparation and tactical execution, while noting that Cruz had badly miscalculated in choosing to attack someone with superior command of both the facts and the relevant law. Progressive activists and Democratic supporters celebrated the exchange as a perfect example of how to handle Republican attacks on voting rights, noting that Crockett had not simply defended against Cruz's accusations, but had systematically proven them false, using evidence that could not be dismissed as partisan opinion. Civil rights organizations highlighted the exchange in their advocacy materials, pointing to it as demonstration that voting restrictions were indeed discriminatory, despite Republican claims otherwise, and that the evidence supporting this characterization was substantial and well documented. Legal scholars praised the precision with which Crockett had cited case law and explained complex constitutional principles, with several noting that her presentation would serve as valuable educational material for students studying voting rights litigation. Conservative reactions varied considerably, revealing some discomfort even among Republicans with how comprehensively Cruz had been discredited during the exchange. Hardcore supporters defended him by claiming that Crockett had been disrespectful, that she had cherry-picked evidence while ignoring legitimate concerns about election integrity, and that liberal media was spinning a policy disagreement as some kind of victory for Democrats. However, these defenses struggled to gain traction because the video evidence was so clear and because Crockett had specifically addressed each claim Cruz made with documented facts rather than opinions or rhetoric. Even some conservative commentators acknowledged that Cruz had been outmaneuvered, with a few suggesting that Republicans needed better preparation and stronger evidence when defending voting restrictions rather than relying primarily on assertions about fraud and state prerogatives. Ted Cruz himself did not directly address the hearing exchange in his immediate public statements, though his social media accounts posted about other topics and his upcoming appearances, suggesting his team recognized that drawing additional attention to the confrontation would be counterproductive. When he eventually discussed voting rights in subsequent interviews, he avoided mentioning Crockett specifically and focused instead on broader arguments about federalism and election integrity, carefully steering clear of the factual claims that she had so effectively debunked. His supporters continued to view him as a principled conservative fighter, but the viral spread of the hearing clips had damaged his reputation among persuadable voters and had provided Democrats with powerful evidence that Republican voting restrictions were based more on partisan advantage than legitimate security concerns. For Jasmine Crockett, the hearing exchange accelerated her emergence as one of the Democratic Party's most effective communicators on voting rights and constitutional issues, someone who combined legal expertise with the ability to present complex arguments in ways that resonated with general audiences. She received invitations to speak at major civil rights conferences, to participate in strategy sessions about voting rights legislation, and to appear on news programs where she could explain the legal issues surrounding election policy. Her congressional colleagues increasingly recognized her as someone who could be deployed strategically in high-profile hearings and media appearances, where legal knowledge and calm composure under hostile questioning were valuable assets. Her fundraising benefited substantially as donors responded to her demonstrated effectiveness in defending progressive values against aggressive Republican attacks. The exchange became required viewing in law school courses on voting rights and in political communication training programs as an example of how preparation and evidence could overcome rhetorical aggression and institutional advantage. Legal educators highlighted how Crockett had structured her response systematically, addressing each claim in sequence with specific supporting evidence, making it difficult for observers to dismiss her rebuttal as mere opinion. Communication trainers emphasized her tactical choices to remain calm while Cruz exploded, to wait for him to finish before responding comprehensively, and to present evidence in accessible terms that non-lawyers could understand and evaluate. Political strategists noted that her performance demonstrated the value of bringing genuine subject matter experts to testify at hearings rather than just political figures who could articulate party positions, since her combination of legal knowledge and litigation experience gave her credibility that pure politicians lacked. The story of Ted Cruz exploding at Jasmine Crockett, only to watch his rant end instantly when confronted with calm evidence, became a defining moment in contemporary debates about voting rights and constitutional governance, illustrating how factual analysis could cut through partisan rhetoric when presented with sufficient skill and preparation. The exchange demonstrated that Ted Cruz's reputation as a formidable legal mind who could dominate any debate rested significantly on carefully selected opponents and favorable conditions, and that when facing someone with comparable legal training plus superior preparation on specific issues, his aggressive style proved ineffective and potentially counterproductive. The viral success of Crockett's performance suggested that substantial audiences valued evidence-based policy discussion over theatrical confrontation, and that politicians who combined expertise with communication skill could compete effectively even against opponents with institutional advantages and larger platforms. The lasting lesson from that Senate hearing was that explosive rants without factual foundation collapse immediately when challenged by opponents who arrive prepared with comprehensive evidence and the composure to present it effectively. Ted Cruz learned, before millions of viewers, and to his visible embarrassment, that attacking witnesses with legal expertise requires more than just aggressive questioning and passionate rhetoric, that actual evidence matters more than volume, and that opponents with superior command of relevant facts can turn attempted intimidation into opportunities for devastating rebuttal. Jasmine Crockett proved that years of courtroom experience create skills directly applicable to congressional testimony, that remaining calm while presenting evidence systematically is far more effective than matching aggression with aggression, and that preparation transforms potentially hostile environments into platforms for educating audiences about complex issues. The exchange reminded everyone that congressional hearings could serve their intended oversight and educational functions when witnesses came prepared to engage substantively rather than just absorb political attacks, and when confrontations were decided by evidence quality rather than just rhetorical performance. If you want to see more analysis of these extraordinary moments where evidence triumphs over explosive rhetoric and careful preparation defeats bombastic performance, make sure you subscribe to this channel immediately and hit that like button so we can continue bringing you content that shows what happens when facts finally get their moment against political theater that too often dominates our national discourse.